Hey everyone, welcome back to the channel. Today's video is a complete courtroom disaster as we witness a full-blown Karen meltdown in court. The kind where self-control vanishes and common sense goes out the
Mr.
window.
Wagner, and
Things
this
spiral out of control
matter, you're before
quickly,
the court
with
charged
shouting,
with civil
profanity,
contempt of
and an
court
astonishing lack
due
of
to your
awareness,
failure
all aimed
to
directly
pay
at the
child
judge.
support and or
And
related
if you're familiar with
expenses.
how courtrooms
Upon
operate,
first conviction,
you already
could be
know
ordered to
this
serve
is
up
about
to
the worst
45
approach anyone
days in
could take.
jail.
It's
If
been a
a
while
second or
since I featured a
subsequent offense,
genuine
up to
Karen in
90
court
days in
case,
jail.
and it's
You
amazing how
understand
fast
the
these
charges, sir?
situations escalate
Yes,
when
I
someone
understand.
mistakes entitlement for
Right.
authority.
The docket
What
before
begins
you,
as a
Your
routine
Honor,
hearing
is
soon turns into a perfect example of how not to act before a
2019-846-DS
judge,
in the matter
and the
of Ms.
outcome is
Kelly
exactly
Bridges
what you'd
versus Mr.
expect
Derek
when arrogance
Wagner,
collides
with
with
Mr.
reality.
Wagner being the
So get
payer.
ready, because
This
this
is an
one is
adjourned
chaotic,
enforcement hearing.
intense,
It
and
was
completely
adjourned to allow
predictable.
him to be
Let's jump right
represented by
into
a
it.
court-appointed attorney as requested. It was originally, prior to that adjournment, a bench warrant hearing for his failure to appear at a referee hearing on June 13th of 2022. The order being enforced today is the modified Uniform Child Support Order dated January 13th of 2020, which states that his current child support is $109. After servicing and processing fees, brings it to $112.50. His last payment was $148.28 on September 3rd of 2021 via unemployment. He has been show cause 3 times with 1 bench warrant and 1 finding of contempt. The previous 6 months at $112.50, he should have paid $675, and he has paid none.
Because he's a bum.
Calm down, Karen. We get it. You don't like him, and that's already crystal clear. But here's the irony you seem to be missing. The enforcement officer is actually doing an excellent job presenting the facts that support your case. Step by step, calmly and professionally, he's providing the court with exactly what it needs. Meanwhile, your constant interruptions, emotional reactions, and obvious disrespect for the courtroom are accomplishing something entirely different. They're building a case against you. Every time you speak out of turn, every sarcastic comment, and every display of attitude weakens your credibility. At this stage, the judge isn't just considering your claims. They're paying close attention to your conduct. When the evidence is working in your favor, but you choose chaos instead of composure, the only person you end up hurting is yourself, and the consequences are impossible to ignore.
Court. As of February 28th of 2023, his total arrearages are $4,747.94. There have been no previous jail sentences with that previous contempt hearing. Mr. Wagner was booked in on March 3rd in the Calhoun County Jail on separate charges. When he was booked in on our warrant, he was in jail from February 16th to February 23rd.
Okay, do you have any questions for Ms. Wills?
Yes. Miss Wills, has he been in jail since February 16th?
No, so he was in jail February 16th to February 23rd. He bonded out on the 23rd, and then he was booked back into jail on March 3rd. And he's been there since March 3rd on separate charges that are not FOC related.
And does he qualify for the LEAP program?
Nope.
No, so with Mr. Wagner, let me make sure that we have his correct address on file. The previous address, he does qualify for LEAP. However, due to, us not being able to get in contact with him and having the bench warrant for so long, he did not qualify. He does now, as long as he doesn't have any other warrants in the state of Michigan.
Okay, thank you. No further questions.
Okay. Any proofs, Mr. Secretary?
Yes, I'd call Mr. Wagner.
Okay, go ahead.
All right, Mr. Wagner, can you hear me?
Yes.
You heard the testimony of Miss Wills, is that correct?
Yes.
Is there anything that you disagreed with?
No, sir.
Okay. So you were booked in, looks like February 16th, and then you bonded out on February 23rd by posting a $100 bond. Is that correct?
Correct.
Are you willing to put that bond amount towards your child support arrearages?
Absolutely.
He needs to pay more than $100.
And you really need to stop talking right now, because openly disrespecting the court and repeatedly interrupting the proceedings isn't a bold statement. It's the quickest way to lose both time and money. And let's face it, those are two things you can't afford to waste when you have a child relying on you. Every outburst, every interruption, and every display of attitude only adds to the consequences that will ultimately fall on you. What's truly in your best interest is straightforward. Stay quiet until it's your turn to speak. Follow the court's rules, and allow the process to unfold. A courtroom isn't influenced by loud voices or emotions. It responds to patience, proper timing, and respect.
Okay, hold on a second. Ms. Bridges, we're taking testimony from Mr. Wagner, not from you at this time. You'll have an opportunity to speak after that, so please don't interrupt.
Okay. All right. Ms. Wills testified that you're being held on other criminal charges in the jail. Is that correct?
Yes, sir.
Do you have a hearing date or a release date for those other charges?
I have a release date on the 8th.
On April 8th,
Yes, sir.
you're expected to be released.
Yes.
Good. Prior to February 16th of 2023, were you employed?
No.
Lie.
Hold on a
Okay.
second. Just hold on. Ms. Bridges, was I unclear about not speaking or interrupting? Ma'am?
So what? Y'all can shake a piece of shit motherfucking hand and say
Hey,
congratulations.
ma'am, if you go off like that, you can be held in contempt of court and go to jail. Do you want to do that?
Just proceed to the fucking court hearing and shut up.
Do you even hear what you're saying right now? At this point, you've already given the judge more than enough first-hand evidence to support a contempt ruling and even a trip to jail. That's what makes this moment so striking. Judge Kirkman isn't known for tolerating this kind of behavior. His courtroom is built on order, respect, and self-control, and those who cross the line usually learn the consequences very quickly. Yet despite the repeated interruptions and obvious disrespect, he stops and gives her another chance to regain control, another opportunity to stay quiet, adjust her attitude, and keep a bad situation from becoming much worse. That kind of patience from the bench isn't a sign of weakness. It's a mark of professionalism. The real question is whether she'll recognize that opportunity before she talks herself into handcuffs.
Ma'am? One more outburst or one more vulgarity and you will be going to jail. You understand?
Good luck.
What, ma'am?
I said good luck. Finish court.
That man signs arrest warrants every day. So there's nothing lucky about what's happening here. This isn't a judge who's unfamiliar with consequences or reluctant to exercise his authority. He's someone who deals with accountability on a daily basis. When he pauses, issues warnings, or gives another opportunity to correct course, it's not because he's uncertain. It's because he's being intentional. The real mistake is believing that patience is the same as weakness. It isn't. It simply means the clock is running out. Every extra comment, every sarcastic response, and every refusal to stop talking doesn't earn her sympathy. It pushes the patience of a judge who knows exactly when and how to bring the discussion to an end. And when that moment arrives, it won't be about luck at all. Only consequences, delivered fairly and without hesitation.
Ms. Bridges, you can ask Mr. Wagner any questions pertaining to the issue before the court, which is his non-payment of child support. Do you have any questions?
I already know why his non-payment of child support is, why he's had a job the whole time working for Larson's Construction, making $26 an hour underneath the table for months now.
Okay, ma'am, this is your time to ask him. This is your time to ask him questions, not for you to give a statement at this point. So if you have any questions for him, ask those.
Okay, Derek, seeing you had money to buy alcohol, why were you not paying your child support?
I was terminated because you had contacted FOC before I had a chance to be placed on payroll, so I was terminated.
That's not my fault. You know you're supposed to pay child support. Pay your shit. Be a man. instead of a bum drunk.
She may be having a full Karen-style meltdown, but to be fair, she occasionally manages to make a valid point. Even so, every brief moment of clarity is quickly drowned out by the shouting, the attitude, and the complete lack of self-awareness. Watching it unfold, it's difficult to ignore the bigger picture. These two aren't just talking past each other. They're reflecting the same poor judgment and unwillingness to accept responsibility. In a strange way, they're a perfect match, two people caught in a cycle of bad decisions. Each convinced the other is at fault while the courtroom quietly records it all. At that stage, it's no longer about who's right. It's about who will face the consequences first.
Court will make the following finding in this matter. In this case, Mr. Wagner has a minimal support obligation of $148.50 per month, including his arrearage repayment in this matter. That, in fact, over the last year, he has, as he stated, he's worked approximately 2.5 months during that time, making $200 per week. On each of those weeks, that he acknowledges that he simply failed to pay, and there's no excuse for not doing so. In addition to that, he did have odd jobs. He stated that he has been hindered somewhat because he has not had an ID or a birth certificate, etc., to acquire employment, but he has not stated any effort he's made to acquire that. Likewise with the GED, other than that he's had no money to do that. The court will find that he has had the present and the ability to pay, that he's failed or refused to pay, and therefore he is in contempt of court. Anything before sentencing, Mr. Sackrader?
Yes, thank you, Your Honor. My client testified that he will be on probation upon his release and his other criminal matters, and he will
Karen,
be.
you and everyone else on that Zoom call are expected to conduct yourselves exactly as if you were standing inside the courtroom. That isn't a suggestion, it's the rule. So here's a simple question the judge doesn't even have to ask. Would you light a cigarette during an in-person court hearing? Obviously not. And if you wouldn't do it in the courtroom, you can't do it on Zoom either. A virtual court session is still a real court session. It's not your living room, it's not a video chat, and it certainly isn't an excuse to ignore basic courtroom etiquette. When the judge has to pause the proceedings to explain something this obvious, it's not the court being unreasonable. It's you showing everyone, in real time, exactly why the court's patience is wearing thin.
Looking for employment to satisfy this obligation. We would ask that any jail sentence be 31 days or less, with credit for 7 days already served in this matter. We would request a purge amount in the amount of $400. Thank you, Your Honor.
Thank you. Well, in this matter, Mr. Wagner, I could sentence you up to 45 days. I'm not going to do that only because it is your first time that you would have any jail time, even though you did have a prior contempt. There was no jail time at that point. What I'm going to do is I am going to sentence you to 21 days in jail with credit for 7 days served. And I'm going to put a purge amount in place of the amount of $500. If you're able to pay the purge amount, then you would not have to serve the balance of your jail sentence. Do you have any questions, sir?
No, Your Honor.
Okay. Court will end this matter at 11 a.m. You're free to go. Have a good day.
That's bullshit. You guys shake his hand and tell him congratulations.
Ma'am, the case is done. We don't need to hear anything else from you.
Fuck you, bye.
That's definitely not how I would have handled that situation. But then again, I'm not a courtroom Karen with no sense of self-preservation. I value my freedom far too much to do something as unbelievably reckless as telling a sitting judge to go to hell. That isn't courage. It isn't standing your ground. And it's certainly not an act of defiance. It's pure self-sabotage. Judges don't need to argue with you, raise their voices, or trade insults. They simply sign the order and let the consequences speak for themselves. When someone willingly crosses that line, they aren't making a statement. They're showing they don't understand power, authority, or the very real cost of disrespecting both.
Hold on, ma'am. The court is going to hold Ms. Bridges in contempt of court based upon the last outburst and the last vulgarity. Ms. Wills, do you have Ms. Bridges' phone number? Can you contact her and get her back?
Yes. Let me just go ahead. If you allow me, would you like me to go off record while I call her right now to get her back on the Zoom?
No, go ahead. We'll just hold on and put her on.
Okay. Hi, Ms. Bridges. This is your enforcement officer. Judge Kirkham was wondering if you could please log back on to Zoom to speak with him. If you could please log back on, Judge was requesting that. Okay, just log right back onto the Zoom room and they'll let you in. She hung up on me. So I'm unsure if she will log back in or not.
Let me see. This may be her.
Okay. Yes, that's her.
Oh, yeah, that's definitely her. I recognize that look right away. It's the, I'm about to join my baby daddy in jail expression. And once you've seen it a few times, it's hard to mistake it for anything else. It's the moment when the attitude finally runs into reality, when all the confidence fades and is replaced by the sudden realization that things have gone way too far. You can almost see it register as she realizes the judge isn't bluffing. The warnings weren't just for show, and the consequences she kept pushing toward are now only moments away. At this stage, the meltdown isn't interesting because it's loud. It's interesting because you already know what's about to happen next. And trust me, this is where everything becomes very real, very quickly.
Good.
Ms. Bridges, I had warned you multiple times about your outbursts and the vulgarity, and apparently that did not have any impact. What the court is going to do based upon the last outburst, ma'am, the court, is she muted? Are you muted, ma'am? You can unmute yourself. We can't hear you.
You don't want to listen to anything I say. You just want to shake this motherfucker's hand and tell him
Ma'am,
congratulations. Let's be a
ma'am,
piece
the
of
court
shit
is holding you in contempt of court. I'm sentencing
You
you
ain't
to
holding me
3
to shit,
days,
bitch. Fuck off.
3 days in jail, ma'am. You will be sentenced to 3 days in jail. You will have to appear on, we'll have her appear on March 17, 2023, no later than 4:00 p.m. to serve her 3 days in jail.
All right, everyone, that's it for today's video. Everything you just watched happened only a few days ago. So if there are any new developments, additional court filings, or further legal consequences involving this Karen, you can count on me to cover them and bring you the latest updates. Cases like this can change quickly, and I have a feeling this story isn't over just yet. If you enjoyed the video, be sure to leave a like. If you didn't, feel free to hit the dislike button. Either way, I'd love to hear your thoughts in the comments because I read every one of them. And if you haven't subscribed yet, make sure to subscribe and turn on notifications so you never miss a future upload. Thanks for watching. I really appreciate your support, and I'll see you in the next video.